Welcome back everybody to our studies of European Union law. In this video we are moving on to the next of our major topics for this particular set of lessons, and this is going to be examining the sources of EU law, the sources of law and the various different ways in which we arrive at those sources, so things like the legislative process. So this is going to be talking about the nature of the law itself rather than the nature of the institutions of the European Union. If you remember back to previous lessons, we spent a good amount of time talking about the roles, the powers, and the competences of the various different institutions of the European Union, finishing with the European Court of Justice in the previous video. This lesson is going to turn our attention away from the institutions, the places in which law is created and adjudicated, to the actual law itself. We'll examine in these videos the concept of EU competence, the sources of European Union law, the various types of European Union law, as well as the legislative process. Now, this video and the next video is going to give us a little bit more indication as to what we mean when we examine the idea of competence. What does competence actually mean within the context of the European Union? Well, competence essentially refers to the matters which the European Union has jurisdiction. So one of the things that's important to remember is that the European Union isn't a state. It's not a state in the sense of the kind of Westphalian understanding of states that we have, like the United States, the state of Turkey, the state of Germany, etc., etc. Instead, it is a collection of states. It is a supranational institution, and it is made up of the member states of the European Union. And so one of the things that has to be recognised and has to be respected in that regard is the idea of the sovereignty of the member states in question. So the people who are, the states, should I say, who are essentially making up the European Union, they have to have sovereignty. And so the question of competence is one that is very important, because when we have the European Union and we have the powers that the European Union has, it gets that power from the states delegating a little bit of its sovereignty, all collectively delegating its sovereignty and giving that the right for the European Union to legislate on these matters. So the question of competence is one that is very, very much of a matter of paramount importance when it comes to the European Union. So since we've mentioned here, since it is a supranational institution, it has limited elements of democratic governance as well. So one of the major critiques of the European Union is how democratic it may or may not be, or at least the lack of democratic institutions. It's a little bit more complicated than that, but fundamentally it is not, in some cases, it's not as democratic as the states which form it and regulate it. And so the kinds of things that the Union is able to legislate and have power over is a difficult balance to reconcile. And we also see that in the era of European politics, there has been a lot of controversy in relation to the kinds of things that the European Union should and should not have jurisdiction over. Brexit is, of course, one of the main examples of how this is operated. So with all that being said, you can probably understand that the concept of competence is something that is regulated quite strongly, namely by Article 5 of the Treaty on European Union. And Article 5 says the following. They say that the limits of Union competences are governed by the principle of conferral. We'll get to what this means in a minute. The use of Union competences is governed by the principles of subsidiarity and proportionality. We'll get to that in future lessons as well. Under the principle of conferral, the Union shall act only within the limits of the competences conferred upon it by the member states in the treaties to attain the objectives set out therein. Competences not conferred upon the Union in the treaties remain with the member state. So what is this telling us? Well, this is telling us is that the idea of competence, the power that the European Union has over certain areas of policy, is conferred to it by the member states in the treaties. So there is a sort of general collective recognition by everybody who is involved in the European Union, including the member states, that they want to be part of the European Union for a particular purpose. The European Union should serve a particular purpose. Given that fact, and given the fact that it should serve a particular purpose, these purposes are set out in the treaties. And then the treaties in accordance with those objectives, of those purposes, will then give us the principle of conferral, where the member states will, in accordance with trying to set out and attain the objectives that are established by the treaties, the member states shall give up some of their powers and therefore create competences to the European Union. Under the principle of subsidiarity, in areas which do not fall within its exclusive competence, the Union shall act only if and insofar as its objectives of proposed action cannot be sufficiently achieved by the member states, either at the central level or at a regional and local level, but can rather, by reason of scale and effects of the proposed action, be achieved better at the Union level. So what the principle of subsidiarity tells us is that where there may be some areas where it's not explicitly set out in the treaties that the European Union should and has to have this power, but it makes sense for the European Union to have this authority given the size and the scale of the action in question, then it makes sense, therefore, for the member states to essentially delegate that authority to the European Union, just because it's more practical for everybody else. The institutions of the Union shall apply the principle of subsidiarity as laid down in the Protocol on the application of principles of subsidiarity and proportionality. We'll get to that in future lessons. National parliaments ensure compliance with the principle of subsidiarity in accordance with the procedure set out in that protocol. Part 4 of Article 5 says that under the principle of proportionality, the third of these issues, the content and form of Union action shall not exceed what is necessary to achieve the objectives set out in the treaties. Again, what this is telling us is that assuming that we're going to have competence, assuming that national member states, which are democratic in nature, are going to delegate their powers to a less democratic supranational institution, that power should only be wielded in a way that is proportional. Proportional to what, you may ask? Well, proportional to the objectives that are set out in the treaties. So this gives us a basic overview of what we mean when we talk about EU competence. The provision here in Article 5 essentially shows us that the concept of competence is something that the Union shall only have with reference to the authority and the consent of the member states. And so this essentially gives us a sort of a nice balancing situation where we have the member states that want to retain as much national sovereignty as humanly possible. But then you also have members of the European Union itself that wants to achieve its goals insofar as possible. And so a balance has to be had in this relationship, and this balance is established by Article 5 and is established through this concept of competence. In the previous lesson, we introduced the subject of the sources of law of the European Union, and we spoke about this idea known as competence. We're going to speak about competence in more detail in this video because the various types of competence is very, very important. That's what we're going to explore in this video specifically. But we noted that from the previous lesson, the idea of competence refers to the areas of policy, the areas of lawmaking that the European Union is entitled to essentially have a say in, or maybe even have complete and total control over. And we remember that the reason why competence is so important and is so vital to our understanding is because of the nature of the European Union as a supranational institution and the ways in which sovereign states have to delegate some of their authority to this supranational institution in order for it to run effectively. So again, we are talking in the sort of general outline about the sources of the law of the European Union, and we're looking at the concept of European competence, EU competence. We'll spend some time examining the specificities pertaining to EU competence. And we'll explain for the most part, this idea where we think about the types of competence that exist. Okay? So, the European Union, in the treaties that the member states sign on to, outlines 3 different kinds of competence that the Union itself will have, okay? And these 3 different types of competence are outlined in Articles 3, 4, and 6 of the Treaty on the Functioning of the European Union. These 3 types of competence are, as found in Article 3, the idea of exclusive competence. Article 4 outlines the idea of shared competence, and then Article 6 talks about this idea known as supporting competence. Let's begin with the first one, Article 3. Exclusive competence includes those areas of European Union law which are, as the name suggests, exclusively and specifically powers and authorities that are within the remit of the Union itself. It means that member states do not have any individual power or authority to legislate in these areas. This is the strongest type of competence, owing to the fact that essentially what this involves is in the areas of policy where the European Union has exclusive competence, the member states have given up and delegated all of their sovereignty to the European Union. Article 3 says the following. It says that the Union shall have exclusive competence in the following areas. In the areas of customs unions, establishing of competition rules necessary for the functioning of the internal market, monetary policy for the member states whose currency is the euro, the conservation of marine biological resources under the common fisheries policy, common commercial policy. The Union shall also have exclusive competence for the conclusion of an international agreement when its conclusion is provided for in a legislative act of the Union or is necessary to enable the Union to exercise its internal competence or insofar as its conclusion may affect common rules or alter their scope. So, given our basic understanding of what the European Union is and how the European Union works, we can understand quite easily why this is the competence that the European Union has. It has competence essentially in the maintenance and establishment of competition policy and the internal workings of the single market, as well as monetary policy for currencies that involve the euro, the centralized European currency, and then also talking about the common fisheries policy, which is a very specific and a very important agreement that is signed between member states of the European Union. And then finally, it also has competence when it comes to the ways in which the European Union as a collective operates in international law. The European Union, in some areas of international law, is essentially operationalized as a single unified unit. For example, when we talk about international trade law, for the most part, the European Union is a single unified unit. The second kind of competence, as mentioned, is this idea of shared competence. The idea of shared competence exists where there is an area of legislation that is retained partially by the member states and then partially operated by the European Union itself. So it means that essentially national sovereignties of member states will retain a great amount of authority in these areas, but then the European Union may be able to step in circumstances where it's clear that the Union's actions could support the vision of the policy in a better way. This is what's really important about the idea of shared competence, is that the rationale for shared competence, the rationale for the European Union essentially giving up and delegating some of its legislation, the member states delegating some of their sovereignty, is because of the general acceptance that the European Union may be better suited to regulate certain areas where the member states may not be. This is outlined in Article 4 of the Treaty on the Functioning of the European Union, and Article 4 says that the Union shall share competence with member states where the treaties confer on it a competence which does not relate to the areas referred to in Articles 3 and 6. So this is, of course, the idea of exclusive competence, and then the competence that exists within Article 6 of the TFEU, which we'll get to in a minute. Shared competence between the Union and the member states applies in the following principal areas: the internal market, social policy for aspects defined in the treaty, economic, social and territorial cohesion, agriculture and fisheries, excluding the conversion of marine biological resources, which is of course outlined in Article 3, the environment, consumer protection, transport, trans-European networks, energy, areas of freedom, security and justice, common safety concerns in public health matters for aspects defined in the treaty. And then they go on to say that in areas of research, technological development and space, the Union shall have competence to carry out activities, in particular to define and implement programs. However, the exercise of that competence shall not result in member states being prevented from exercising theirs. In areas of development cooperation and humanitarian aid, the Union shall have competence to carry out activities in the conduct of common policy. However, the exercise of that competence shall not result in member states being prevented from exercising in theirs. If we go back to the areas of shared competence in Article 4, Article 4.2, you can sort of understand why these are seen to be areas of shared competence. Take, for example, environmental policy. Environmental policy could quite easily be within the remit of the individual member states, and for the most part, is a policy within the general remit of individual member states. But you could also understand why the idea of environmental policy could cross borders and could eventually be something that ought to be regulated at a more supranational level, given the international cooperation which is required for good operating environmental policy. So something like environment and environmental policy can be seen as something of a shared competence area of policy. You can see on the one hand why a member state would want to retain its sovereignty in this area, but you can also see on the other hand why the European Union would want to have some kind of a competence in terms of being able to apply policy in this area. Finally, then, we have Article 6, which is supporting competence. Supporting competence is the weakest form of union competence, and essentially, as defined in Article 6 of the Treaty on the Functioning of the European Union, what supporting competence is areas where the European Union has a very limited ability to have influence on the authority and power of the national sovereignties of member states. Article 6 says that the Union shall have competence to carry out actions to support, coordinate, or supplement the actions of member states. The areas of such actions shall, at European level, be the protection and improvement of human health, industry, culture, tourism, education, vocational training, youth and sport, civil protection, administrative cooperation. So these are areas which you would understand to be the weakest in terms of areas of policy where there is the desire for the most cohesion between the various member states. In terms of things like tourism policy, it doesn't really matter which member state and which member state you are in, because for the most part they will have different policies in terms of their tourism culture, and specifically culture as well. And so as a result of which, it doesn't seem to make much sense for a supranational institution to take the sovereignty of a member state in relation to culture or tourism and regulate it at the supranational level, especially too given the fact that Europe is a particularly culturally heavy continent in the world. It is an area where culture is very, very different depending on whether or not you are in Italy or in Spain, if you're in France and Germany, or if you're in Latvia or Lithuania. These have different cultures, these have different tourism needs and ideas, and so as a result of which, it wouldn't make much sense for the Union to be regulating that at this supranational level. Welcome back everybody to EU law. In this video we're continuing talking about the sources of law, but more specifically one of the subsidiary issues relating to the sources of law, which relates to the concept of EU competence. Now, in the last lesson, we spoke about competence in more detail. We examined the nature of EU competence as part of the ongoing discussion about the sources of European Union law. The idea of talking first about competence essentially sets the stage for the overarching discussion about the law that is made, because the law that is made has to be in accordance with the competences of the European Union. And so when we get to talking about treaties and when we get to talking about decisions, regulations and directives, we will get to looking at the process by which these laws are made, but with reference and with in the back of our minds at all time, this concept of there being this competence that is required as a result. So as part of this ongoing discussion, we're going to talk about the idea of proportionality, which is a principle that some textbooks and some lawyers or academics will separate as a distinct issue from that of competence. And while that is potentially probably quite true, the way that it is a distinct concept, it is still nevertheless one that is interwoven into the idea of competence, since proportionality pertains to the kinds of competences that the European Union has, in particular, to the lawmaking ability and the policy regions in which they can create and discuss law. So, when we think about proportionality, we mentioned it briefly in the last lesson, but we didn't actually give it a name. We just referenced it with reference to the treaties as we discussed it, because we noted that when we think about the actions in relation to the European Union and the actions related to whether or not the European Union has competence to essentially prescribe policy in certain areas, they must do so in terms of actualizing this in accordance with the proportionality of the treaties. So the concept of competence is essentially asking the question of in what policy areas, should I say, in what policy areas does the European Union have the ability to create law? The idea of proportionality is that given those areas, does the measure in question that is being created fit in line with the purpose of the treaties? If the treaties are prescribing the European Union with certain competences in certain policy areas, is the particular measure, whether that be a directive or a regulation, for example, do these measures actually fit in accordance with the treaties themselves, such that they are not going above and beyond what the treaties prescribed as a competence of the European Union? That is essentially what proportionality is telling us. The action must be done for a reason that is conferred onto the treaty. If the action goes beyond this remit, if it goes beyond what the treaty says is part of the European Union's competences, then it is beyond the scope of the treaty, and therefore it is disproportional, and it is therefore not allowed. It would violate this principle of proportionality. So competence tells us about the areas of policy that the European Union has some kind of sovereignty over. Proportionality essentially tells us the limits to the prescribing of policy in those areas. Okay, that's what proportionality tells us. We can see an example of proportionality in the Vodafone case from 2010, because this case, in terms of its facts, revolved around the concept of roaming charges on mobile phones, and specifically the price of said charges. If you go abroad, you have a mobile phone, you maybe make calls, you may have to pay roaming charges on those calls, owing to the fact that you are abroad and outside the jurisdiction of that particular phone network provider, for example. Now, the European Union adopted Regulation number 717 in 2007, and on the basis that essentially they were limiting the price of those roaming charges. Sometimes roaming charges could be very, very expensive, and people sometimes don't realise it and take phone calls abroad, and then they come back and they see that they've got a phone bill of hundreds and hundreds of pounds, which isn't particularly ideal for anybody. But the European Union sought to try and limit the price of the roaming charges by implementing this regulation, Regulation 717. And they did so on the basis that they would be allowed to do so as they were acting under the competences of the European treaties. This was Article 95 of the EC Treaty, which is now Article 114 of the Treaty on the Functioning of the European Union. So, in terms of the competence was enshrined in Article 114 of the TFEU. Now, Vodafone and other phone network providers sought to challenge this view. They sought to challenge this regulation on the basis that the regulation was acting outside of the specific competences of the treaty. It was the same policy area. They weren't suggesting that they didn't have any recourse or any sovereignty to act in this particular policy area. In fact, in reality, they actually did make that argument as well. They made a competence argument as well as a proportionality argument. But in terms of the proportionality argument, if it was disproportional, it means that they were acting beyond the express wording of the treaty and going beyond what the treaty prescribes as an authority that the European Union has. And so acting disproportionately meant that the regulation would have been unlawful. In reality, like I've just said, the Vodafone case will be talked about in the next lesson as well, because they made arguments on the basis of competence, proportionality, and subsidiarity, which we will get to in the next lesson. The claim, ultimately, though, was rejected by the European Court of Justice. The European Court of Justice said that when it comes to the proportionality argument specifically, as I've just mentioned, other arguments were levied. The Court of Justice held that it need not be shown that a measure in question is the most effective or the best measure that could be implemented, so long as the implementation was not manifestly inappropriate. So when we think about proportionality doesn't have to be a very high standard necessarily, or it's a relatively high standard, but it doesn't have to be the highest of standards. Essentially, proportionality tells us that a measure in question should be proportional to the objectives of the treaty's prescriptions in the provisions in which they have competence. And so as a result of that, that does not mean that the measure implemented, the regulation, has to be a perfect regulation, or it has to be a regulation that has no faults and no flaws whatsoever. Policy is never and is really that precise. In reality, the policy has to be, or the regulation has to be, one that is just not manifestly inappropriate. In another case, we see the Court of Justice lay down what they believe to be the general considerations and the general questions that you have to ask as part of a test to discover whether or not the policy in question, the regulation, the directive, etc., is or is not disproportionate. And so this case gave us, with the Court of Justice, these questions that should be considered. And the three questions that are asked are as follows. They ask the question first, is the measure suitable for achieving the objective that is part of the EU's competence? So the EU has competence as part of the treaties, okay, and the treaties lay down certain objectives for what that particular area of policy ought to be, the EU ought to aim for, essentially. And so the question that we first ask is this directive or regulation suitable for that? Is it suitable for achieving it? If it's not suitable for achieving it, then it suggests that it is disproportional, essentially. The next question is it necessary? So could you have done it a different way that would have been less of an infringement on the sovereignty of member states? Is it necessary to have done it in the way that it is being done? This again doesn't necessarily mean it has to be perfect, but it just suggests that it is not manifestly inappropriate, if we go back to the wording of the Vodafone case. And then the final question is, does it have excessive impact? Does the impact of the policy go beyond the objectives of the competence of the EU? So is there further considerations, or are there further implications or further things that have to be worried about when it comes to the competence of this, when it comes to the effectiveness of this particular policy? If the policy does the thing that the EU competence gives it prescription to do, but then it goes above and beyond this and does a bunch of other stuff as well, then this suggests that it has an excessive impact and then would potentially be disproportional. Welcome back, everybody, to our studies of the law of the European Union. In this video, we're going to finish looking at the idea of European Union competences, and finishing by looking at this idea known as subsidiarity. Now, this is the third of the three major principles that sort of loosely are described in the broad context of competence. There is the idea of competence in and of itself, the idea of the European Union having a specific mandate and remit to be able to legislate and to regulate in certain areas of policy. There's the idea of proportionality, which we've looked at in the previous lesson, and which essentially examines the ways in which competence can be justified. Essentially speaking, where the European Union has competence in specific areas, especially in areas where we're talking about supporting competence or even shared competence, we have to think about the measure that is being implemented by the piece of European Union legislation, and the ways in which this is proportional to the end goal that is established, and is essentially trying to justify the reason for that particular piece of legislation to exist. Subsidiarity is the final basic principle of European competence. Now, essentially, what we're going to be doing is looking at the idea of competence in relation to this idea of subsidiarity. We'll explain what the principle of subsidiarity is. We'll talk about how it is defined in Article 5 of the Treaty on European Union, and then we will finish by looking at a couple of cases which illustrate the idea of competence and the ways in which competence has been raised as a point of law and a matter of law in the European Court of Justice. So let's begin then by just defining and explaining what subsidiarity actually does and how it actually works. So the concept of subsidiarity, what it essentially does is provide what you could describe as an exception to the basic rule of competence. Essentially speaking, what subsidiarity tells us is that in areas where the European Union does not, on its face, have competence, i.e., it does not have competence as defined by the primary law of the European Union, the European treaties, they may act if one of the member states, or if the member states as a collective, have shown that they are unwilling or unable to achieve the same outcome as the European Union if they had acted in that circumstance themselves. So essentially what it tells us is, in areas where the European Union does not have competence, but in areas where it seems to be the case that the European Union are better suited or are actually able to achieve the outcome that is set out that member states are unable to do, then the principle of subsidiarity essentially provides a remit for the existence of the European Union's ability to legislate in those areas. Let's look at what it says actually in the treaties themselves, and we have to look at Article 5, specifically Part 3 of Article 5 of the Treaty on European Union. Article 5, Part 3 says the following. They say that under the principle of subsidiarity, in areas which do not fall within its exclusive competence, the Union shall act only if, and insofar as the objectives of the proposed action cannot be sufficiently achieved by member states, either at a central level or at a regional and local level, but rather can, by reason of scale or effects of the proposed action, be better achieved at Union level. It goes on to say that the institutions of the Union shall apply the principle of subsidiarity as laid down in the Protocol on the application of the principles of subsidiarity and proportionality. National parliaments ensure compliance. So really it is the first part of this passage that is the most important for us to actually examine and to actually get an understanding of what subsidiarity means. It is saying here that in areas where there is not exclusive competence, so where the European Union does not have the ability and does not have the remit to essentially explore the regulation of certain policies, they can act, the Union can still act, if the proposed action cannot be sufficiently achieved by a member state. Now, it gives a couple of reasons as to why this may be the case, as to why a member state may be unable to achieve the actions that is necessary or that is proposed by the policy in question. And they say that by reason of scale or effects. So essentially, this gives us an indication of the kinds of actions and the kinds of policy areas and legislation that can actually fall into this category of subsidiarity. So by reason of scale, it might be a circumstance where the proposed action, the proposed legislation, the proposed end goal should be utilized and should be regulated by the Union as a whole, because of the scale of the measure, such that a single member state acting on their own would be unable to achieve the outcome that is aimed at for the purposes of that particular area of policy. And so as a result of which they may go, well, let's go to the European Union and let's regulate it at a supranational level, and so having a desired scale. In addition to this, you could also think about this as a result of the effects of the proposed action. In some cases, it may be the case that a proposed action doesn't make sense to be regulated at the level of the member states because the proposed action regulates something that potentially could cross borders, so things relating to the internal market, which we'll get to in a second, all of which would fall under the remit of, firstly, it would fall under the remit of the exclusive competences of the European Union. But in situations where it does not fall within this exclusive competence area, you can then make the argument and come to the conclusion that it would be better regulated at the Union level under this idea of subsidiarity. Let's look at a couple of case examples to illustrate these points. And we begin with the 1997 case of Germany and the Parliament. In this case, the facts are a little bit complicated, but essentially relate to financial law within the European Union and the sort of monetary policy of the European Union. The European Union had essentially put as a requirement under a specific directive. The directive was the Deposit Guarantee Directive, for member states to ensure the existence of a special scheme for deposits which would then be applied to the credit institutions of the member states. Essentially, what this scheme tells us, or at least what this directive outlines, is that it essentially requires that only in the circumstances where the member states are a part of this special scheme can therefore the credit institutions of those member states actually be able to take from the deposits of their customers. So that's essentially the long and short of the idea of this particular policy and this particular directive. Now, what happens here is that Germany seeks to challenge this directive. They would bring legal action on the basis that the European Union had failed to account for the principle of subsidiarity in the text itself. This is a requirement under at the time, Article 190 of the EC Treaty. So this essentially tells us that there was a general obligation of the European Union that when they issue a directive, they must show and they must explain within the directive why this directive does not fail the basic principle and the basic test for subsidiarity. That's essentially what it tells us. And Germany said that the European Union had failed to do this. They had failed to account for the fact that the principle of subsidiarity is a thing that exists and is a thing that they have to reconcile, and they have to explain why this directive does not fail the principle of subsidiarity. Now, the European Court of Justice, however, made a different analysis. They actually rejected the argument that was made by Germany, and they argued that the European Union did, in fact, have the adequate explanation in relation to the subsidiarity principle. Essentially, what the directive did, or what it was argued, was that without the implementation of the directive, the issue of unavailable financial deposits could cross borders. And essentially, without the implementation of the directive, if the same kind of policy was implemented at the level of a member state, this actually wouldn't sufficiently solve the issue that was at play here, given the fact that financial deposits could, unavailable financial deposits, and the issue of unavailable financial deposits could cross borders. The resulting factor here being that a single member state, or the member states and the national parliaments of member states regulating this area, would not be sufficiently adequate in terms of the achievement of the goal, which is of course part of the therefore remit of subsidiarity within the European Union. And so providing a sufficient explanation for why the European Union ought to have competence in this area was done under this idea of subsidiarity. It was seen to be the case that it would not have the desired goal, or the sufficiently desired goal of achievement, if it was done at the level and under the remit of the sovereignty of national parliaments. Finally, then, we have two cases from 2005 on the Alliance for Natural Health, case 15404 and case 15504. These were both cases where claimants brought similar action against the European Union. And it was a case that involved rules that surrounded specific foods which were considered supplements. And these were considered supplement foods because of the nutrient information and the amount of nutrients and the specific nutrients that were contained in them. Now, as part of the directive that was at issue here, Directive 2002/46, essentially what this did was it implemented new rules on these specific foods, on these specific supplement foods, with the view to harmonise the national rules surrounding these foods, and essentially to ensure broader harmonisation of consumer protection regulations under the European Union's single market. So this is an important element of the single market. When we get to looking at EU single market law in future lessons time, we will see that one of the major elements of essentially constructing the single market is this idea of harmonization at the supranational level, essentially taking the sovereignty out of the member states and applying rules across the entire European Union to ensure that each of those rules are harmonized across them. A similar thing happens here. We have the Directive 2002/46 that does that very same thing. And so this was essentially two cases that were brought against the Union on the basis that the claimants had believed that the directive had improperly infringed on the rights of the member states. Essentially, the member states had the right to regulate this area of consumer protection themselves, and so the European Union essentially did not have competence in this area. And so the question of subsidiarity was raised again, the question of whether or not this would fall into the basic principle of subsidiarity and therefore be a directive that was legitimate. The European Court of Justice argued that according to Article 114 of the Treaty on the Functioning of the European Union, essentially what this did was give the European Union specific competence in accordance with the principle of subsidiarity to improve the conditions of the single market. Essentially, that gave them relatively broad scope in terms of their abilities to regulate in lots of different areas, because they can do so under the motivation of, quote, improving the single market. And Directive 2002/46 absolutely was aimed at trying to improve the single market and the construction of the single market by harmonizing the rules across member states, specifically concerning these supplement foods with the nutrient information. And so something that harmonization seeks to achieve therefore means that the European Court of Justice argues that the European Union is able to apply the principles of subsidiarity to issues that fall under the remit of Article 114 of the Treaty on the Functioning of the European Union.